All right. Hi, everybody. This is Konstantinos from Athens Legal Tech. I have the pleasure to host tonight a joint event with European Legal Tech Association on Remote Courts, the European Perspective. We have a jaw-dropping panel of guests, and I would like to introduce them right now. We have Holger Teige, President of ELTA and Managing Director of Infotropic Media. We have Markus Hartung, lawyer and mediator and founder of the Bucerius Center on the Legal Profession at Bucerius Law School, Hamburg, and co-founder of ELTA. We have Nicolino Gentile, partner at BLB Studio Legale, ambassador of ELTA in Italy, and founder of Legal Tech Italia. We have Luis Acairo Sanchez, senior judge, administrative court of first instance from Santander of Spain. And last but not least, we have Alexandru Stanescu, partner at SLV Legal. The format of today's discussion will be each guest will present for 5 to 10 minutes a brief overview of the current developments on remote court hearings at the respective country, and then we're going to follow up with an open discussion. And to all our guests and speakers first, but then guests, you can literally jump on the discussion after the presentation and you can freely ask, so we can make it more interactive. I would like also to inform you that this event will be recorded, and without further ado, I will pass the floor to Holger. And maybe I could ask him to do like a very short introduction of ELTA to our audience. Thank you very much.
Okay, thank you, Konstantinos, for inviting me and everyone else on this webinar. Yeah, if we start with a little short introduction of ELTA. ELTA was founded in 2016 by a couple of lawyers who thought there should be a separate organization for legal tech enthusiasts in Europe, because there wasn't one back then in 2016, and legal tech in Europe was developing very rapidly. It kept becoming a hot item. So they just founded it. It started as a purely German initiative, but grew rather quickly into entirely European organization. So we have now members from over 44 countries, even beyond Europe. There are ELTA members from Peru and the United States, but mainly, of course, ELTA members are from European countries. And we have a unique structure. We have so-called ambassadors, so there are people that are, well, our foot on the ground in a lot of European countries. At the moment, we have 30, or as of now, 32. We just added 2 new ambassadors in the United Arab Emirates and in Latvia. So those are people, or the link between ELTA and the local legal tech community. So they are a basic part of ELTA and very important for the development of ELTA. So what ELTA wants to provide for the legal tech community in Europe and beyond is first an institution that educates, provides information and knowledge about legal tech, the legal market solutions, and so on, what's going on in every country, because apart from the large jurisdictions, there's not a lot of information available of what is going on, say, in Lithuania, Serbia, Bulgaria, and so on, in Malta. We want to change that so that there's some information available on what's going on in legal tech and what solutions for what problems can be already implemented. And we want to provide a platform for networking, to build up a community for exchange of information, again, best practices and so on, that people just know that they are not alone, that there are already a lot of people interested in automating legal processes and bringing the legal profession into the 21st century. So that's essentially what ELTA is doing, and everybody is free to join. We're very happy. You can join as a natural person, or you can join as an organization. Just visit ELTA's website and click on the button, apply for a membership, and we will do the rest. Okay, so let's. What do you want to? Back to Konstantinos, or
no?
You just
shoot with your presentation,
Okay.
and then it's Marcus, and then it's Nicolino, and then it's Akairo, and then it's Alexandru in the end.
All right. So
Okay.
share my screen. Go. That should be the right one. So can you see? Can you see my presentation?
Yes, yes.
Okay, good. So let's talk about the market in Russia and remote courts, what's going on in Russia, especially in regard with COVID pandemic, what did change, what was already available, what's new in the market. So I would like to start with a short introduction into the court system in order to get an impression what's going on in the court system in Russia. So in Russia, you have basically a two-tier system. So apart from the constitutional courts, you have civil courts entirely for disputes between natural persons, and commercial courts, or so-called arbitrage courts where at least one of the sides in a dispute is a legal entity. And there's a huge difference between those two tiers, the civil courts and the commercial courts, in terms of automation. The commercial courts are very, very well equipped technically. So you can file electronically in both court systems, in the civil courts and the commercial courts. The civil courts are based, or the automation is based on a so-called state automated system justice, Pravosudye, which is a much more inferior system to the system of commercial courts, which is called the Index of Commercial Court Cases, or CAT arbitra. I don't know, I really can't explain why there's such a huge difference. The system of the civil courts was started even earlier than the system of the commercial courts. It's just probably there are different companies that are tasked with developing the system, and the company who started and is still maintaining the system for the commercial courts is the largest legal tech vendor on the Russian market. So it's no coincidence. They are very sophisticated, but you can file electronically in both systems since 2009 in the commercial court system, and since 2014 in the civil court system. In the commercial courts, 50% of all cases are filed already electronically. In the civil courts, it's much less. So there you see the difference already in the system. The only thing you need to participate in electronic filing and in online sessions, you need to be registered as a user at the state services portal Kososlugi, and as of now 103 million Russians are already registered. There's 2/3 of the population. You get an electronic signature, and then you can take part in electronic filing, have access to documents of a court case. So 63 of the 118 commercial courts, they are equipped not only for electronic filing and for seeing all documents related to the proceedings, like the decision of the court and so on. So usually every decision of a court case is filed into the system and electronically available free of charge the next day. But in 63 of the 118 courts, you can access all the materials, all the documents of court case electronically. You should be able to do that with the civil courts as well, but it's not the case. You cannot access all the files because not everything is available electronically. If you're looking at the number of judges, there are 25,000 in the civil courts and 4,500 in commercial courts. And court cases per year in 2020 there were 37 million civil cases in civil courts and 1.5 million in commercial courts. And 99% of all those cases are heard and decided upon within the time limits provided by the procedural code. So there's not a lot of backlog in cases in Russian courts, which is quite good, and it's probably a result of the high level of automation in the court systems. So if you are talking not only about electronic filing, access to all the materials in a court case, but about electronic or online hearings of courts or online proceedings, there are two types, and they are based on the procedural code. First is dedicated conferences. It's a court system. So in order to take part in an online hearing via a dedicated conference line, you have to go into your local court, and they will set you up, and you can take part in an online hearing. And since 2020, it was it's not part of the procedural court yet. There are now amendments in the parliament. They will decide to include it into the law. But as of now, it's just something that can be done via web conference, or you can do it from your home or your office. Connect to the court. The only thing, the problem in Russia was always the issue with identification, because in Russia you have to identify yourself as a part of the court, the case. So if you're the plaintiff or the defendant or legal counsel of the side, you go to the court and present your passport and you identify yourself. So that's a little bit more difficult online, because in Russia you just can't join a hearing without identifying yourself. But if you have that e-signature from the state service portal, then you can take, and that they will take it as a kind of identification. One issue is that the technical support is, or say, let's say in commercial courts, 100 of 180 commercial courts, they are already online as of May 2021. And funny thing is, they have been, or the availability of technically they could have online court hearings for 10 years now. So they started in 2009 with the system, and there was already a menu item, online court hearings, but nobody has been using it before the pandemic. So that made it available for them to roll it out very quickly. So they, in end of April 2020, the first commercial court came online, and in May they added 74 of the courts, and then the rest until May 2021. So 100 are now online, and they had 230,000 hearings already for this year. So quite a lot. In the civil courts, 90% of the applications for an online hearing are denied for various reasons. Most of the time because the court is not equipped to do it. And I've talked to lawyers, and they told me that they applied for court hearings, say at 12 o'clock, and have been denied because of the reason that the IT guys have their lunch break at this time, so they cannot set up the online system. So 90% of the hearings still, that gives 3.7 million hearings that have been provided online, but nevertheless, it's in a lot of cases the application has been denied. In order to take part in an online hearing, both sides have to be, how is in English, they have to be ready to participate in an online hearing. And if there's a problem, technical problem, or in order to take part, you have to provide all the evidence beforehand. You have to send it in, and a lot of lawyers are reluctant to take part in online hearings because then you cannot decide whether you show some document as evidence or not, and it's harder to react to opposing counsel and so on. So you can always vote for postponing an online hearing, or say you're not happy with how the online hearing went, and then they will postpone it, and you can continue offline. But if both sides are content with the outcome, then it's a normal hearing. And I think there will be no way back to purely offline hearings. People are already, especially in the arbitrage or the commercial court system, already are very happy with using that system. It works. It works very well. And I guess in the civil court system, they will now make it part of the law that you can participate not only via the dedicated servers of the course, but you can participate from home via webcam, and then that will probably also be used widely. Okay, that's it. Thank you.
Okay, that's cool. That's very interesting lessons from the Russian experience, especially the last one that you shared. I mean, like 90% of the applications are denied for various reasons. Okay, so we're back. We have. I don't think we have enough time now to discuss entirely about Russia. So I would propose to move forward with all the presentations, and then we can have a discussion by the end. Marcus, would you like to continue?
Yeah. I'm sorry, I don't have any slides. The reason for that is that there are not very many good news with regard to online courts or remote courts. Germany is basically a country which is non-digital by all means. We are obsessed with data protection. The moment we hear digital or computer or data, we think of data protection. So that makes it difficult for a country which is rather slow in its development. But we are in the middle of a development. The court system is on the verge to move at snail's pace to digitalization by means of offering electronic access to the public and to lawyers, one, and two, to introduce e-filing in courts. Now, that doesn't look or doesn't sound like a disruptive innovation or a major change, but for German court systems, it is a major change. The German legal system is basically very paper-driven. If you have a lawsuit, and it's irrelevant whether it's a civil lawsuit or a public lawsuit or whether it's a criminal thing, everything is paper-driven. So if you want to file a claim, you write something, and normally you send it via post. You can use telecopier, and for lawyers, it has been introduced a certain special mailing system for lawyers, which is highly confidential with an E2E encryption. The courts on the receiving end don't have all yet electronic filing, so the messages from lawyers will be printed out and put into physical folders. So that's the way where we stand at the moment.
I understand. So how did allow me to make this a bit more interactive. So how did the court system react during COVID?
Yeah, I was just about to.
I'm sorry.
Come to that point. Now, when COVID came, all of a sudden people were not allowed to leave their homes and to go into rooms with too many people in it, and all of a sudden people were reminded that since 2013, there is a provision in the Civil Procedural Code that courts can be done via video. But that's pure theory, because most of the courts don't have the technical equipment to offer video conferencing. Now, it may seem easy for you because you are in your office and or at home, and you sit at your computer and you start your webcam and you have a system like Zoom or so, and you can talk to other people, and you would wonder, why on earth can't courts or court proceedings be that simple? Well, the reason is, if you have hearings which are basically oral, you have to make sure that the public has access to these hearings. Now, in the German legal system, we don't have publicity which goes via video to the entire world. Public means for those people who are in court, in the courtroom, sitting in the back of the room and looking and listening to what is happening. And that means if you want to conduct oral hearings via video, you have to make sure that the people who are physically in the room can share with those people who join via video. And that makes it complicated. So it's not just a switch overnight to say, use this provision and use your webcam and use your laptop to conduct oral hearings. Now, over the year, we in our law firm, which does employment law only for employees, and we have only one office in Berlin, but we do our business nationwide. So we have always applied to have all the hearings via video. And as Holger said, in 90% of the cases over the summer and autumn last year, that was denied by all sorts of reasons. No technical equipment, no training of the judges, no. That is changing as judges realize that doing it via video is very helpful. It speeds up things, and you can put people on mute. And that is for a judge a very compelling feature if he conducts an online hearing. So I cannot say yet where we will end up to, and whether we will have a situation where we would say, well, 50% or 60% of our hearings will be done via video, because we all know it's sometimes it's just necessary to plead while you're present. And very often, once you have these management meetings and these short meetings where just to make sure where do we stand in our case and what has to be done, video would be ideal. And once lawyers in Germany, who are not the most disruptive, innovative bunch of people, have realized how good it is for your business and how much more clients you could get while contacting them remotely, they will start to support this. So I feel slightly bad when I'm telling this, because Germany is known as such an effective, well-industrialized, strong economy and so. But basically, when it comes to digitalization, it is not that good. So at the moment, if you want to conduct a legal proceedings in Germany, then be prepared that most of that has been done as it has been done decades ago. Writing on paper, filing via the post or fax. The courts have to accept electronic, we will have e-filing in 2026 at the latest. So that is their deadline. So today is 2021. That is this sort of period we think in Germany to get digitalization on. What I see even in Russia or in China, how things are really taking up speed. That's not the case in Germany, I'm afraid. So that is all I can tell you today.
That's very interesting.
Take any question if there are any, because I will have to leave at 2 minutes to 7 or so. But but probably
I think we can do fast the next presentations,
yeah,
and then we can have like an open discussion.
Okay.
But I think the picture that you painted is pretty much, I wouldn't say relates to the entire continent, but pretty much sums up the same challenges that we all face in our countries. So next one is Nicolino Gentile from Italy.
Hi everybody. Thanks, Konstantinos, for inviting me. I'm very happy to be here with you all. I will try to give you a quick picture of the situation here in Italy about the remote courts and how we get to this pandemic crazy period. Maybe I say a little prepared about it, because the digitalization of justice system and of the trial system, at least in the civil trials, it has been commenced in Italy since more than a few years, because the beginning of the civil digital trial system is in 2005. So we've been creating, I can say step by step, a digital lawyers experience and digital judges also court experience. But obviously the pandemic that we are facing still now, and who knows for how many months, let's say, I want to say months, not more, we will have to deal with it. So I will share my screen, and I have a really brief presentation. Hope you can see it.
Yes, we can.
Obviously is not on the first. Okay, thank you. So this is me. My name is Nicolino Gentile. I'm a partner with BLB law firm. I'm ambassador of our beloved association ELTA that Holger presented very well at the beginning of his speech, and I'm the founder of Legal Tech Italia, which is our newborn project in legal tech field. Is a place not just online, but basically online in this crazy period place for our legal tech based project. When I say our, I say BLB and all the partners that work with Delta, also with Delta too, obviously, with our firm in the legal tech sector. So how can I skip? Just to ask you, do you see only the presentation or also the Zoom bar?
We can see the presentation.
Only the presentation.
Yes, now it's perfect.
Okay, not also the thumbnails of you people. That okay.
No.
Because it is a kind of crazy,
Yeah.
craziness of my computer. Okay. So remote courts in Italy at the first sight, at a glance. As I was saying, we have the civil trial and criminal trial digital system, with whose experimentation was dates 2005, but has been let's say in force since 2014, and then gradually became mandatory. Up to date, it is mandatory for all courts, apart from the Giudice di Pace, which is the court that states on cases under 5,000 euros. But by the end of 2022, it should be mandatory as well for the Giudice di Pace. Also, the criminal trial digital system is in use since a few months actually, and in the criminal law section of courts there is more resistance for the traditional traditionally held hearings because maybe because of the fact that those hearings are more spoken one, I can say, than the civil hearings. We have also appeal courts and cassation courts trial on digital systems. And we also have, since 2012, if I'm not wrong, the obligation to have, we as lawyers, but also the companies and legal entities in general, are obliged to have a certified email address, which substitutes the registered mail, traditional hard mail, and the physical professional domicile of lawyers. So we as lawyers and companies and legal entities can be served by courts or by lawyers or other entities formally through a certified email message, which is the same of receiving a traditional registered mail. Is there a register of this PSC? We call it PEC, Posta Elettronica Certificata, and this register lists all addresses, PEC addresses formally published on several registers. Now, with the pandemic, we've been obliged, I will say, to experience and to have civil hearings on virtual or in written form. If I have to say, to talk about percentage, I can say that the written civil hearings, which is basically an exchange of statements to be filed through the digital system, they are the 60% of total hearings. Then we have 30% of virtual hearings, and then 10% of in-presence traditional civil hearings. Parties can ask for have a traditional hearings, but the judge, they usually prefer the virtual one if they don't decide for a written one. The civil trial system and the criminal trial system, digital system, works through the submission of statements and decree by the judge and statements from by the parties. A quick focus on virtual hearings. They are via Teams, only via Teams, or Skype for Business, but basically it's via Teams. And a link is sent in the hearing scheduling decree, the decree issued by the judge. My experience, it can happen that judge's assistant use the same link, not only for hearings or for just one hearing, but also for courses or meetings of the judge. Not so many days ago, I saw in my Teams conversation box the chat among judges that were attending a course, and they were exchanging their opinion. So it is a security issue, not so little, let's say. Judge can hold an hearing online, being in his office in court, or also wherever, and the wherever has been allowed just recently, a few months ago. Parties can ask for an hearing in presence, so a traditional one. And parties have to be in the same place of their counsels, but the counsel can submit a motivated request before the court to authorize the party to connect from a different place, and this request is usually authorized. Let's think in this restriction due to pandemic times, you cannot move from, let's say, Rome to Milan to get to my office, when you can obviously connect from your place. And this is a useful thing, but is also a problem, because obviously parties and counsels which are not together, they maybe have to communicate between them, among them. So there's a lot of WhatsApp. which is more than a joke, because in my opinion and also in my experience can be a problem. But I have to say that if the judge is able to connect the hearing, the virtual hearing properly, they are an opportunity to have hearings that are more clear and not emotional. This is not so true in criminal law trial, but in my opinion, I have a question basically, but if it is habit or because the criminal hearing is more a more spoken one than the civil one. But we are going on the path of virtual hearings also in criminal. Written hearings are basically a contradiction in terms, but they obviously help to save time, and they can drive the trial on a more facts and law-founded path, no emotion, not too much rhetoric. So you just exchange your reasons, and in 80 or 90%, it's enough, in my opinion, of the cases, it's enough. Anyway, parties can ask for an in-presence hearing. So what can we expect, or what can we work for more, given that now we have this situation? For sure, more automation in justice processes. This means gain and create a data culture in legal and justice documents and processes, more accessibility to justice services for justice users, which are people, and micro and the small medium enterprises, which are the 90% of Italian, but not only Italian, also European economic texture. We can expect, and we can work for a more digital mindset in everyone, in lawyers, in judges, and in court officers, because maybe clients are already digitalized. Or is this true? I think so. I think yes, but for sure clients are not happy to deal with a slow, especially not Italian clients. So if you think people from countries where justice or economy or bureaucracy is not so slow and is fast, they are not happy to deal with a justice system which is unclear, which is a bureaucratic driven, and as I said, slow. So how can we change the digital mindset, and how can we help the digital mindset to change? Maybe we can use new methodologies, legal design. We can really think and seriously think about digital transformation. And maybe we can also think about a new generation of jurists in the post-pandemic 21st century. We also need to think about and to gain more funds, because innovation and transformation needs funds, but it seems that the recovery funds money will be put on innovation programs also in justice. Here you can find a few references about some laws.
So it seems, Nicolino, that
Yep.
Italy is on fire, actually.
Yes, it is. It is
Italy
really on fire. It is really on fire. Yeah.
It is remarkable that you have 30% of the civil law trials being implemented virtually. One impromptu question here. I mean, well, I guess, you know, obviously that that adoption of going on full virtual mode definitely reduced the backlog of cases. But my question is, does virtual mean faster also in the case management in the court system, or, you know, it's a normal process, but it's being done virtually?
In a certain way, I'd say faster as well.
Okay.
I say faster as well.
We can focus on that later on. It's one of my questions.
Yes, of course. But to think about this, you know, the velocity of the trial, I think that we cannot really and seriously set our ideas if the virtual hearings and the virtual system is faster than the traditional system in these times, because these times are very crazy. So the judges and the court are full, their workload is very, very high, and they are full of things to do. And the transformation has been, too much fast. But the grounds and the basis, they are all there. And the really amazing thing, I think, is that you can start a trial and end the trial without leaving your computer right now.
Yeah, that's crazy indeed.
That's
all right.
Crazy, but
Let's move on with Spain then, with a senior judge from the Administrative Court of Santander. Thank you, Akairo, for being with us.
Let me interrupt sharing.
Okay. Thank you very much for having me. It's an honor to attend in this roundtable to share experience and learn from European colleagues. My name is Akairo, like Egypt City. I was born in the Canary Islands, Tenerife. I am a senior judge of Administrative Court in Santander, and I hold trials related with everything that has to do with public administration, such as public contracts, foreign matters, or fundamental rights. Okay, to adapt to the format of the event, I will try to summarize how we deal with the pandemic and what the current situation in Spain. To make it more understandable, I'm going to share my screen and divided my... one moment. Okay. Now, it's okay?
Yes, that's perfect.
Okay. I'm going to divide my presentation in 3 parts. However, as a brief introduction, I have to say that in Spain, the state of alarm was declared on March 14, 2020. One of the consequences was the effects of the activity of the court, because it included the suspension of judicial proceeding and court deadlines, with the exception of some urgent proceeding. Most of us were sent home to wait. It was a really hard and complex situation, especially for family, divorce proceeding. I have friends who didn't see their children for more than 50 days. For this, perhaps this image summarize the response of Spanish justice. One moment. Okay. This was our reality. I can say I'm proud, because as judicial system, we fail. For this, it's a great opportunity to explain what we have made since then. Well, the first part is regulatory and challenge. Okay, regulation before the pandemic and during the pandemic. The truth is that we had a law, 1985 of 1 of July, that regulate how we must work, which was reformed in 2003, and the possibility of remote trials was incorporated. Since then, we are allowed to hold trials remotely, as long as we guaranteed 2 requirements. One, a simultaneous bilateral communication of image and sound. And the second one is ensuring, in all cases, the possibility of contradictions and the right of defense. Even we are obligated to use when we have the means. Well, we have another no law, is a protocol, is an instruction which was approved by Spanish General Council of Judiciary, which aim is only record or remind us that we are obligated to use our technical device. Well, this was before the pandemic. During the pandemic, our government has a Royal Decree Law 16/2020, and in sorry, one moment, please.
We can see everything. No worries.
Do you hear me?
Yeah, we can hear you. We can hear you. and we can see
Okay.
anything.
Okay. Our government passed this royalty-free law, and in its Article 19 set the priority of online trial. But was the only condition was if the court has or not has the technical equipment. Other solution which take our government was to pass a guideline on 25th May with only like a protocol. It was really useful, but not with. It's not really. Sorry, I don't remember the word in English. And the third law was 3/2020, 18th of September, which extend the priority of electronic presence until 20 of June 2021. Well, the truth was what we must do. What should we do? We had to face at least these three main challenges: technical implementation, platform, guarantee the right of defense, and identification of witnesses and expert witnesses. Well, here is where I really start my presentation, because Spain is special in its territory organization. Why? Because we have 17 territories, okay? I need to use this image because reflects what we face. Not all of them have the same management system in the court. In fact, there are 9 different management systems which operate separately from each other. Furthermore, in some regions, the court didn't have the necessary basic technical means such as a webcam. But in our case, in Cantabria, in the north, we did. Well, as you can see, each icon represents a different court management system. And our legal framework doesn't require the use of a specific platform. So the real problem was another. None of us had known how to deal with remote trial. In this situation, we faced the pandemic. In our case, we decided to try to hold a remote trial the 11th May of 2020. And fortunately, we got it. But this image could summarize our previous feelings. Because with our framework legal, we didn't know what was going to happen. Because we were fully aware that the end doesn't justify the means, and it must be a trial with all guarantees. So anyway, I have to say that it's going quite well the situation in Spain, because bilateral and permanent communication, the contradiction and the right of defense are being guaranteed. So the result, the potential of remote trial in Spain are this one. According to the latest data of the last week, over the last year in Spain, more than 355,000 trials have been held remotely. It means almost 20% of total trials. The estimates are that in the next few years, this figure could be more than half of all trials in Spain. But not all courts have the same percentage, of course. This depends on each kind of court, but surprisingly, the courts which are using more remote trials are criminal courts. In our case, an administrative court, we hold more than 80% of all trials remotely, and I can assure that we guarantee all requirements. But
I'm sorry, Cairo, could you do you have your mobile on, or else, because there is a strange sound that is being repeated like every few seconds?
No, so I put my auricular. Okay, better so?
Yep, that's perfect.
Okay, I continue. So the result of this transformation, digital transformation, is that the first one, more than 355,000 trials have been held remotely in Spain during the last year. It means almost 20% of all trials. But the real potential is the accelerated changing we are experimenting. One of them is the electronic file. I heard before how Holger talked about it in Russia. And I have to say that we have electronic file in our court. So each lawyer or professional can access to it only with one click. We have digital signature. Other problem during the pandemic was we having it. So the file rests, the dream is a little expression, in the court, because we couldn't move and go to the court, and we couldn't sign anything. For this reason, this transformation, one of the priority was to set the digital signature. Another one was with witnesses and expert witnesses in several trials. With our management system, we can generate virtual waiting for witnesses and expert witnesses. Perhaps the first problem is try to identify them, but for this, what we do is try to identify previous day or several hours day. In other case, the only recommendation we have is by the exhibition of the identity card. Another good result is the electronic judicial agenda. Our management system allows us to use an electronic agenda that, by keeping it updated, allows lawyers to know if the trials or actions scheduled for the next day have been cancelled or not. In this way, we avoid wasting lawyers' time as a consequence of last-minute cancellation. Other benefit is the data flows and guide processing. Perhaps it's the most innovative thing because it's working with a guided processing of the procedure. The key is that each procedure responds to a scheme from its beginning to its end. Through guided processing, what is achieved is that it is the management system itself that offers the worker directly the resolution that has to be used at all times without having to know the status of the procedure in depth. Other result, precisely this week, they have installed in our personal computer intelligent voice recognition system, which will allow us to do sentence without typing on the computer, because speaking directly is enough with the reduction in time that this suppose. I think that in 5-6 minutes, this is an overview of how it is the situation in Spain. I hope I have managed to explain in my brief presentation. Okay.
No, I think what I can see that that Spain is following the path of digitization, and in a very robust way. One question: are these results and all these data? Do these results concern the administrative part of the judicial system in Spain, or the entire court system, civil cases, etc.?
In general.
In general, all right, okay.
Yeah,
so
yeah.
you're doing pretty well. So as you said, it's like 20% of the total hearings. So that's pretty. That's a bit less than Italy, but still, you know, quite considerable.
Okay. The 80% is what we do in our sorry. The 80% is what we are currently do in our court in Santander, number 2.
Okay.
And in general, administrative court could be 50%, 40%. In civil court, depend, because we have different courts which the whole trial, 90%, 95%.
Okay, okay, that's cool. Marcus has to check out because he has a professional meeting at 7 p.m. So maybe he would like to do some closing remarks before we jump to Alexandru and international arbitration. Thank you, Marcus.
Everything okay?
Yes.
Thank you for this great event. It was very interesting, and I'm envious what is happening in Spain and in Italy. It's a shame.
We are envious too. We are envious too, you know, in Greece. Yeah.
Okay, guys.
Thank you very much, Marcus. Thank you very much. Bye-bye. So, Alexandru, here comes.
Thank you very much.
Here comes the courts breaker.
Yeah, I mean, for me, you know, it's very interesting to see the developments in Europe. I'm based in Bucharest, so I can also tell you that from the Romanian perspective, of course, things are going well. They implemented the electronic file some time ago, but again, I was talking with some friends who are judges here in Bucharest, and they were telling me that, especially for civil cases, parties might use during this shady times, to say so, dilatory tactics. My Teams did not open, the Skype did not work, so, you know, in order to gain another hearing, or, you know, to gain more time, and, you know, the parties are seen with more leniency in Romania, given that, you know, the technical advancement, technical education is not that high, like across Europe, I would say. When we're talking about remote justice. However, my topic today was relates to arbitration and what can, you know, remote courts and practitioners from more across Europe can learn from arbitration. Of course, it will not be able, arbitration will not be able to solve the problems that the courts have, because, you know, the courts are the courts. However, in terms of civil matters, commercial matters, arbitration had a long time to perfect some of the, you know, the innovations in terms of hearings and how you can do them more efficiently. So this is the topic that I wanted to discuss with you. Let me just quickly share my brief presentation. Is it okay? Do you see it well? Okay. It's going to be very brief, and basically I'll start from why arbitration and how it, you know, it went as a preferred solution for solving civil and commercial claims across different countries and continents. Basically, you know, it bases its force on the first pillar, which is the New York Convention on Recognition and Enforcement of Arbitral Awards across more than 180 countries across the globe. So basically, if we are arbitrating between Romania, Greece, we can then enforce it in New York or in Paris as we wish. There's basically no obstacle to it. And the second one was the standardization of the law for arbitration based on the UNCITRAL model law, which basically defines the context under which the lex arbitri, the arbitration of the jurisdiction where the arbitration is being held. Namely the place of arbitration. And, you know, they brought standardization across the world, which got very useful when you know, you will see the principles of physical versus remote hearings were being brought. Another difference between the courts and arbitration is the fact that arbitration, because it's delocalized, the big institutions like the International Chamber of Commerce, ICC, the London Chamber of International Arbitration, and other institutions across the world are competing. So they are always bringing new technologies and new innovations in order to attract the cases. So you would want your arbitration to be administered by ICC Paris or by LCIA in London. So while in the case of normal courts, if you are to be set in Germany, your court will be in Germany. It's not that Germany will compete, German courts will compete with French courts. And in general, the competition brings a lot of innovation. So that's why arbitration was using electronic means far beyond, years ago. I wanted to share with you the fact that also in arbitration, the principles, principles of a fair hearing and solving a dispute within a reasonable time, they all come from, the same root as we have with the courts, namely, the protection of the Article 6 of the Charter of Human Rights, or the European Charter of Human Rights. Whereby the civil rights and obligations of a person must be determined in a fair, in a public hearing, within a reasonable time by an independent and impartial court established by law. While the public hearing and established by law were taken out of arbitration because the parties so agreed. So basically, you can agree to have your own arbitral dispute without the eyes of any other party but the two parties and the arbitral tribunal. The rest are, principles of international law which apply to courts and to arbitral tribunals likewise. So in terms of remote hearings, the main issue were the equality of arms, and to make sure that adversarial proceedings were being dealt with. And equality of arms, it's mainly based on the fact that both parties need to be heard and need to have the opportunity to respond. And we've seen from a survey, which is a recent survey of 2021, brought by the ICCA, which is a very interesting one. Basically, they surveyed more than 78 countries across the globe to see whether there is a right to a physical hearing in international arbitration. Should there be a right of a physical hearing which is not respected by an arbitral tribunal, then the whole arbitral proceeding can be annulled, and then what's the point of using arbitration? And very interestingly, by surveying legal experts from all these jurisdictions, the authors found that there's no express provision in any of the law related to arbitration in any of these jurisdictions who grants a right for a physical hearing. While the institutional model law contains a provision who says that the parties might request an oral hearing. Oral hearing does not equate to a physical hearing. So basically, again, in countries like Argentina, Croatia, and you've seen there, Dominican Republic, Ireland, Poland, Slovak Republic, Spain, it seems that in case of a dispute to the fact that the arbitral tribunal gave an oral hearing opportunity, but not a physical one, meaning a remote hearing, the judge in these countries, by interpreting their arbitration law, would say that just providing a remote live hearing would be enough. And the last point here relates to the fact that the arbitral tribunal could even still order a remote hearing despite the parties' agreement, which is very interesting because in general in arbitration, the will of the parties is the most important one. However, if a physical hearing would bring more delay for the arbitration, or undue delay, the tribunal could decide that no physical hearing is needed and replace it with a remote hearing. So that I think those are very interesting because the conclusions, because they mix the world of arbitration with the law that at the end of the day in each country regulates how arbitration is being dealt. My last point relates to another survey which is made every year, and this year White and Case and Queen Mary University of London decided to choose to look also on the technical aspects of arbitration. And I think it's interesting from the point of view of the user. In the arbitration, the clients are more vocal because they are paying for it. So this survey was brought by clients of arbitration, by lawyers, by companies who are using arbitration. And two areas struck my attention and would be useful for us. First of all, the question is, if you had a scheduled in-person hearing that could no longer be held in person at the time, would you rather proceed with a virtual hearing, postpone the hearing, or proceed only on the basis of documents? And as you see, 80%, which is vast majority, would say that no, I'm fine with virtual hearings. So basically, virtual hearings in the world of commerce, it's becoming more and more acceptable, and people, when they have to choose, they will choose virtual hearings as an alternative without any doubt. The second question relates to the fact that the presentation discusses about what type of interactions would you use? And I would draw the attention to two areas, to the fact that substantive hearings are still preferred in person, while procedural conferences and hearings can be done 48% virtual, or the rest by a mix of virtual and present. So it seems that still the beneficiaries of private justice would go for oral hearings and face-to-face in-person hearings, but only for substantive, very crucial points of a case. For the other procedural parts, they would opt for virtual. Very last point. I provided you some practical tools from the arbitration world. There are a couple of protocols which they don't talk that much about the law, but they talk about how hearings should be organized. And there are some very good practices, like for example with witnesses, the clean desk policy, when you need to interview a witness or to cross a witness, then to have how to arrange everything in a room. So there's the Seoul protocol with very specific points. The London protocol describes what would a platform for hearings should contain, and they are platform agnostic. They were the biggest law firms in London who were gathering forces in bringing the principles of how platforms should look like. And there's a new protocol by New York Bar and ICCA on cybersecurity for hearings. So all this can be brought in for practitioners or for the judges and lawyers who are going to design the new systems for remote courts in Europe. Thank you very much.
That's pretty cool. Thank you very much for your presentation. One quick question. Do you know the numbers? I mean, have you witnessed any shift during this year, 2020 and 2021, a shift from traditional court hearings to international arbitration?
Yes, I've seen this, especially for high stakes cases, which if prior priorly they would have gone to courts. Because of the COVID, they would change to, because the parties can choose even after the dispute started, and they can go to arbitration.
Oh, even after?
Yes, even after. And they preferred this because they were able to establish their own schedule, and then they could meet with the tribunal online directly without any other issues.
Okay.
So it provides maximum flexibility. That's why in terms of pandemics, arbitration boomed.
That's pretty cool. Can you do me the favor to unzip the presentation? And
sure.
Thanks a lot.
1 second.
Does any of our participants wants to shoot any question to our guests, speakers?
If I may, Konstantinos?
Yes, sure. Thank you, Vasilis.
So thank you very much for the event. It was really an excellent opportunity to get an overview from many jurisdictions. And I think it would be, the interesting part is that this, as soon as we upload the video as well, I think it's going to be of interest for many of the different countries of the participants, not just for us. So thank you everyone very much. But besides that, I need to admit that I'm a bit surprised, to be honest, by many things. First and foremost, I think it's the first time I've ever heard a judge, and I'm talking about Akairo, admitting that the justice system failed. So that's a first for me. But besides that, it's impressive how well Spain and Italy are going, especially compared to countries like Russia and Germany. I honestly wouldn't expect that. So two questions on that. First of all, when it comes to Spain and Italy, and since Akairo mentioned an intelligent voice recognition system, are there any thoughts about implementing more advanced systems like artificial intelligence related stuff in your judicial systems? That goes to both Italy and Spain. And also a question to all the speakers, and maybe Holger could also, I would like his input on that. Isn't it strange that Germany is a data protection leader, Russia is a cybersecurity leader, and they are both reluctant in deploying such systems? Do they know something more than we do, maybe? Or is just, I don't know, how could anyone explain that? Thank you.
For the last part for Germany, I think that's partly an excuse. Of course, the Germans are quite hesitant to share personal data, but I guess the problem is deeper with the lack of digitalization in the German industry, the German society in general. So I wouldn't say that that's just in order to safeguard personal information of the German citizens. It's just you hear it again and again that the last technical invention in the German judiciary system has been the fax machine. So and unfortunately that. It is the last real invention. They had a huge problem with the system of secure email, what Nicolino was talking about in Italy, for exchange information between lawyers. Just a couple of days before the start in 2018, the German Chaos Computer Club, kind of hacker community, they made it public that it's not so secure as they thought. So you can hack it, and it never went online. So they returned now to put it online. I don't know it, but it's secure now or not. But it was a huge issue in the German legal community.
Akairo, would you like to make a comment? Because yeah.
Okay, thank you so much. I have to say that currently we have reason for being proud, not at all for the first reaction when we close and we will go home, but these last 2 months we have really been well. Respect to the artificial intelligence, there is no any project about it, so I can respond. Sorry. I have to say other things that I think it would be relevant. We have the Spanish government have a project which called Paper Zero. Okay, the main is disappear the paper of the court. In our case, most of all files are without paper, are electronic. 80% more or less of professional even don't need go to the court, because since the first writing, since the first act, it's all by electronic process until the virtual hearing, and the sentence is notified electronically.
That's very impressive. So guys, I would propose to wrap it up and do some closing remarks. Shall we start from Holger, because I know that he has a meeting in he has another meeting in 10 minutes. So
Yeah, thanks again, Konstantinos, for putting that together. It was very interesting to listen, and because usually you don't get that information so concentrated and from people who are at the very center of what's happening in their country. So it's very interesting to see what's going on in Italy and in Spain and in commercial arbitration. Because I've been a long time fan of commercial arbitration, and I know it's quite an conservative community. So it's good to see that they are also looking in that direction.
Maybe I would add like a final question to all of you. Like, how do you see this playing out from next year? Hopefully that we will be like a COVID free world. I mean, will we witness the court systems going in a full virtual mode or not? Just just few your feedback on that.
Probably not fully virtual, but it would be good if there's at least the option to have an online hearing. Probably there will never be in 100% all court hearings online, but it's good if you have the choice, if you have the option to participate online. That might be good, because that is probably, unfortunately, not the last time we will have problems with a pandemic or with anything else. Might be thunderstorm, whatever puts a certain court out of operation, and then you have to do it online anyway.
Yes. If I may step in, I completely agree with Holger. 100% of hearing and of judicial activity online. I think we don't need it, but we need the option. So we need to have the option. And just talking and so answering to Vasily's question about also from Italian side about projects in among judicial system, also from the side of AI. I'd like to mention a couple of projects, one of the Court of Cassation, Corte di Cassazione here in Italy, and one of the Court of Appeal of Brescia, and they are working with legal engineers and developers in order to create a database of decrees and judgments, let's say engineered in order to create to get data from the from these judgments, and this way help also the possible predictions of judgments in the future. Is a pilot. They are both pilot projects, but the essential things is that the Ministry of Justice is sponsoring them. So is there an opening in the AI and in the machine learning in justice from the government, from the state point of view, let's say? And just last thing, Court of Cassation and also the Court of Appeals, they are issuing protocols to us lawyers, asking for, let's say, fulfill a few requirements in writing our deeds, our statements, because this will help the machines to, let's say, eat and work all the data. We are talking about data. We as lawyers talking about data is a new thing, but it's becoming day by day a more actual and real thing.
They need to eat their food. That's
yes,
what you want to say.
Yes,
exactly.
Yes, exactly.
So last comment from Cairo, Alexandru.
Okay, I couldn't agree more with Nicolino. We don't need that all hearings were virtual, but it's necessary to have the opportunity to continue working in cases like pandemic, and any case to have the opportunity to do virtual hearings more or less 50 or 60, 70% of all cases is possible. So I think that it will still take time, training, resources, willingness on the part of all those who are involved in the administration justice. I think that this movement is unstoppable.
All right. Alexandru?
On my side, I'll start by saying, that the future is hybrid. And I think this is the word, the saying of 2021, the future is hybrid, and remote courts are part of it. So my take was that we're going to see a mix between online and offline. It's also true that even, for the visionaries who would want remote courts 100%, you need to do a cost-benefit analysis because with all, the maintenance of a fully automated, let's say, network, the stockage of data, the cybersecurity, all the trainings that need to be put into, let's say, an old administration of justice across countries of the European Union, it might cost far more than the benefits that it might bring. But then again, the option to have online hearings is very important, and I think that more and more we will be progressing to that aim. However, I think that the European Commission, European Union will have a strong voice here whenever the time will come, by providing again a kind of like it happened with other areas of the law, where they will say they will start with a directive and then they will propose a regulation, and then everybody will be prepared for that second stage. That's my take on it.
All right, 2 words. We want hybrid, we want hybrid, we want the option.
Yeah.
That's what I keep as the tagline for this event. Thank you very much, and let's hope for a better future. Thank you very much again.
Thank you.
Thank you all.
Thank you all.
Bye-bye, guys.
Bye-bye.
Thanks a lot.
Bye.
Bye.
Thanks.
Bye.